Blaine Cluten for Cluten Law, answering a question today about at what age a child in Oregon can choose which parent they're going to live with. It's unusual, but in this case, the answer is very straightforward. The answer is at age 18. There are some different ways that the child's interests can be heard by the court and considered by the court, but ultimately, this is a question and an issue for the parents to decide, and if they can't decide, then the court decides. So how are their voices going to be heard if they're not 18? There are circumstances where a judge will listen to a child during a custody or parenting time dispute, and their voices can then be heard directly in the court by the judge. But most lawyers and a lot of parents agree that this is not generally an appropriate forum for kids to be heard in. Can be traumatizing, and although the court will listen, ultimately they're not bound by anything that they necessarily hear, and they're ultimately going to decide based on best interests. There's a procedure in Oregon, there's a law in Oregon that allows that if the child requests an attorney during a custody proceeding, parenting time proceeding, that the court must appoint an attorney to represent them so that they can be heard on for their wishes. If a parent requests an attorney for a child, then it's discretionary about whether or not the court's going to appoint an attorney for that child. Again, these are just ways to be heard, but the judge still is going to decide based on best interests. There's another method that children's voices can be heard, which is through a custody evaluation. A custody evaluator will interview children along with other witnesses, folks involved, the parties, and write up a report. And through that report, ultimately, if the case is not settled, the judge will then consider that evaluator's report, and those thoughts, statements, and wishes will then come in through the report. But once again, it's going to fall based upon the best interest of the child. There are obviously children that think that their voices should be heard and considered, and Oregon is unique in this respect that it has to be at age 18. And I have described some of the different instances where the voices can come in, but in no case is the judge going to be bound by anything that they're hearing in any one of these methods, even if it's through an attorney, even if it's through a custody evaluator. If you have further questions, please contact an attorney. This is Blaine Cluten for Cluten Law.